Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey, everybody. Welcome to another edition of the Federal Newswire's Lunch Hour Podcast. I'm your host, Andrew Langer. So glad you could join us today. I'm very glad that our guest can join us. His name is Ilya Shapiro. He is a constitutional scholar. He's a senior fellow and director of the Center for Constitutional Studies with the Manhattan Institute. He's also the author of one of my favorite books on the Supreme Court, Supreme Disorder, the Judicial Nominations and the Politics of America's Highest Court. We're going to get into your Substack, Ilya. We're going to get into all of the things you're up to. I actually want to start here. I don't know if you've seen this piece that just came out in Politico by someone named John Harris. He's written a piece. I'm looking at you. You haven't seen this yet, have you?
I have not.
You have not. All right. Well, the piece is called "The Best Way to Save the Constitution from Donald Trump is to Rewrite It." And I want to before we start talking about the Supreme Court and the politicization of judicial nominees, I want to get your thoughts. There are a lot of folks, both on the left and the right, who are talking about rewriting the Constitution. There's the Convention of the States movement that's out there. You were someone who has been a deep thinker about the Constitution for a very long time. Before you were at the Manhattan Institute, you had your brief tenure at Georgetown. We're going to talk about that. You were at the Cato Institute for many years. But what this impulse to rewrite the Constitution, this always disturbs. Now, listen, don't get me wrong. There are things that I would like to see perhaps fleshed out. Maybe the definition of public use in the Fifth Amendment. But your thoughts on this impulse to rewrite the Constitution, again, to achieve some kind of political end?
It's kind of ironic that the people that most complain about the breaking of norms in the Trump era and protecting the Constitution from Trump are the ones who are undermining our institutions, whether it's the Supreme Court or the Senate or anything else. I mean, look, societal distrust is at an all-time low.
Right.
Political polarization is high. We're not in kind of a high-trust society anymore, and there are a lot of structural issues with our kind of socio-political situation, shall we say. But I don't think the rewriting the so-called parchment barrier is going to do anything in Jefferson's terms. That is, if people don't want to observe the words on the page, whether they're from the left or on the right, tweaking those words isn't going to do much. And Andrew, actually, it's fortuitous that you raised this issue, because just this morning I have a piece up at the Washington Examiner called "Can We Ever Have a New Constitutional Amendment?" For the last few years, I've been part of the National Constitution Center's Constitution Drafting Project, where they've had 3 teams of scholars, libertarian. I was captain of Team Libertarian. There's conservatives and progressives. Nice. And we created new, we looked at, do we need to start over with the Constitution, make amendments, what have you. Our conceit was that we had the easiest job. All we needed to do was add "and we mean it" to every provision, and there you go. But that was, you can read about that on the National Constitution Center's website. But the second stage of that project was to getting the teams together and to see if there was any overlap, any ability to reach consensus or at least agreement on particular amendments. And now, obviously, we weren't able to hold hands and sing Kumbaya and come to agreement, given disparate differences in values and political theory. But we did come together and propose 5 constitutional amendments, not on anything of deep ideological salience, obviously, but things like adding term limits to the Supreme Court while fixing it at 9. This, I don't think, fixes. We can talk about. We will talk about the Supreme Court in the future. Smoothing out the process for impeachment. Removing the requirement to be a natural-born citizen to be president. Making the whole amendment procedure somewhat easier. So very technocratic sort of things. So anyway, that's my piece at the Examiner. That's a project at the National Constitution Center. I don't think we're going to have broad-scale agreement to do what I think is ultimately the solution to a lot of what ails us, and that's to have a lot more federalism and separation of powers, so you don't centralize decision-making in such a large, pluralistic society.
I don't know if you and I have ever talked about this. I'm about 15, maybe even 20 years ago, I've been having conversations with Todd Zawicki over at George Mason about the concept of the 17th Amendment. For those of you who don't know, the 17th Amendment calls for the direct election of senators. I think that was a huge mistake. Like a lot of these things, we have this impulse towards, democracy. Not that I don't believe in democracy, I do, but I believe we are a republic for a reason. What are your thoughts on the role that the 17th Amendment and the changing of the way that we elect senators or select senators, how has that changed how has it changed federalism? How has it changed the balance of government?
Well, in our proposed Team Liberty Constitution, we did send it back to the states to decide how they want to appoint senators. But that plus some of these other measures have more to commend themselves in the sense that they would increase public confidence in the system rather than changing anything on the ground.
Sure.
And I actually don't think that, I agree with Todd's full analysis that the 17th Amendment was a mistake, as most progressive era reforms were. But I don't think at this point it would change that much in practice. I don't think there would be many, if any, states that would go back to having their legislatures pick senators. There would be an outcry. How can you be so anti-democratic and take it out of the hands of the voters and things like this? But the Senate has become, not just because of the direct election, but other developments, open primaries, decline of party power, all these different things the Senate has become much more populist and akin to the House. There's very few differences between the Senate and the House these days. The filibuster is one, longer terms is another, but that's about it. And so, yeah, I'm sure repeal the 17th Amendment, sure, but in theory that's a good thing. But for practical purpose, I don't think it would change much.
Well, right, it's like everything else, right? There are no. I don't like using the phrase silver bullet anymore. There are no panaceas. There are no fix-alls. There are no cure-alls here. Everything, and there are always unintended consequences. We certainly saw that with the 17th Amendment. Let's pull it back a little bit, Ilya, because I want to talk about your journey to the Manhattan Institute, which is an organization that I adore. For folks who don't know, Manhattan Institute, they deal a lot with things that not just inside cities and what's happening inside cities, but also the big ticket, big picture items and issues. The City Journal is a wonderful publication. But let's talk about this. You and I, we had a conversation. You were still at Cato. You were getting ready, and we didn't know this at the time, getting ready to leave Cato to go over to Georgetown. Normally, I would be reluctant to discuss this because a lot of folks don't like to discuss these kinds of controversies. You've been very open about this. You have a great Substack. You used to call them blogs. Now it's a Substack channel. What is it called? Shapiro's Gavel. You've written about this. Talk to us about these circumstances, being in limbo, being appointed to head this constitutional center at Georgetown, but then immediately being beset by folks who have challenged your legitimacy to be there. Talk about that.
Yeah, so I was appointed executive director and senior lecturer in the Georgetown Center for the Constitution, and as I learned, that's very necessary because the rest of the law school is basically the center against the Constitution.
Which again is insane. Right? It's this issue of, we have folks who have said that Trump broke constitutional norms, yet we have folks who are trying to break constitutional norms all the time. I'm sorry, Ilya, go ahead.
Yeah. Two wrongs don't make a right.
Right.
So I've been at Cato for almost 15 years.
Yeah.
And I wasn't necessarily looking to leave, but I'd become vice president. I'd written a well-acclaimed book, which now is updated with a new paperback edition that just came out in July, I should say to all your listeners, updated through the last two Supreme Court nomination battles. You can also get it in still cheap hardcover, the CDs, Audible, all the rest of it. But I got this opportunity from Randy Barnett, who's a leading constitutional scholar at Georgetown, who founded this center, to join him and to run his center and to have more of a public face for originalism. Exciting opportunity, new type of challenge, new type of impact, sort of thing that I might, that appealed to me at this stage in my career. A few days before I was set to join Georgetown, it was February 1 was supposed to be my start date, was when news of Justice Breyer's retirement leaked. And I was commenting to the media about this. This is obviously within my bailiwick.
Sure.
And late that night, I was traveling. I was in Austin, Texas, in my hotel room, and I was getting upset. I was doom scrolling on Twitter, not a best practice.
Oh boy,
I should say.
Yes.
And getting upset about the comments and President Biden's position that he would be limiting his search by race and sex. He famously said on the campaign trail, and now reiterated, that it would be a black woman. And I thought, look, if I was a progressive Democratic president, who would I pick? And I thought, oh, Sri Srinivasan, who was on Obama's shortlist for the pick that ended up going to Garland. He's the chief judge of the D.C. Circuit. Very well regarded, very sharp, already influential. But he's Indian American and he's a man. He's not a black woman, so he's automatically disqualified. And I posted my comments to that regard on Twitter in sharp language. I said by operation, by operation of logic, since the entire universe of people who are not black women are automatically disqualified. In my estimation, if Judge Srinivasan is the best, then everyone else is second best, less qualified. And I phrased that as we would end up with a, quote, lesser black woman. And really it's the focus on those two words that the manufactured outrage mob on Twitter descended on me as I slept. I tweeted this out and then went to bed. Woke up, everything had exploded.
Wow.
And away we went. And those were, I documented this on my Substack. There were 4 days of hell. The dean of Georgetown ultimately suspended me with pay. I was put on paid leave while they, quote, investigated my tweet.
Listen, I'm sorry, nothing worse, by the way, than going to bed and waking up to some kind of controversy. Lord knows, I've been there myself. I have a good friend who is a radio and television producer who long cautioned me about getting involved in needless Twitter fights, but who has, there's that famous story, Ilya, of the woman who tweeted out about her trip to South Africa and went off of social media, and 18 hours later she lands in South Africa and finds that she's fired from her job. I mean, this is essentially, that's the extreme, but you got very much of a taste of this. So talk about the investigation, though. I mean, this is, not that I want to spend all of our time talking about this, but I think this is an important story to tell. Go ahead.
Yeah, I've detailed this in various writings, including on my Substack, Shapiro's Gavel, which you can subscribe to for free or paid. It's all described what you get for all these various levels, and it's typically the sort of stuff that I put there that I wouldn't necessarily publish in the Wall Street Journal, although I did publish a bunch about. In fact, my resignation letter was in the Wall Street Journal. But anyway, or on in normal media. You get the deep cuts from my psyche, as it were.
Sure.
So it was 4 days of hell, followed by 4 days of purgatory. I was treating this seriously. My friends at FIRE, the Foundation for Individual Rights, and it used to be education, now it's expression. They've expanded their remit. Wonderful, wonderful organization, nonpartisan, non-ideological. They just like free speech, But they helped me out with crisis management and PR strategy and providing a lawyer for me. And 3 weeks later, the Diversicrats, the Office of Institutional Diversity, Equity, and Affirmative Action, interviewed me. And it was this kind of banal thing. What did you mean with this tweet? Tell me more about the context, etc. It was a little ridiculous, but had this interview and then nothing for weeks and weeks and months. And at this point, my lawyer was like, "Look, don't criticize Georgetown publicly, but short of that, the blinders are off, or your hands are no longer tied. Go be an expert on the Supreme Court. Go talk about free speech, whatever." And that's what I did. So for several months, I went back into the arena and I said, this is what I do. This is why you hired me, because I have this voice and this perspective and all of that. And ultimately, it became apparent to everyone that this was a cynical delay to wait for the students to get off campus to then reinstate me on a technicality, which is what they did. It took them 4 months to figure out that I wasn't an employee when I tweeted, and so I couldn't have violated the policies on harassment and anti-discrimination.
Wow.
But as it turned, I celebrated that technical victory, but then when I got the report in my inbox several hours later, this diversity office was setting me up for a fall. And as I detailed in the journal and in my resignation letter, anytime I would say something that someone claimed offended them, that would create a hostile work environment,
Sure.
subjecting me to discipline. And so I, in consultation with my lawyer, with Randy, with my wife, who's a better lawyer than all of us, I made the decision that I had to get out of there, and I made what lawyers call a noisy departure. Sending my resignation letter to the media and announcing my move to the Manhattan Institute on Tucker Carlson's show, as one does.
Because I want to talk about this issue of speech and due process and the Kafkaesque nature that we find ourselves now in, where again anybody who can claim offense all of a sudden has this kind of an upper hand. It very much creates a truly something that only Franz Kafka could have imagined. Talk about that, but also talk about that in the more general, societal concept and within the context of the ideas of due process. This idea that how can you have any kind of a fair shake if someone can just sort of claim offense at something, claim that their feelings were hurt. Talk about that.
This is the big difference now versus when I was in college 25 years ago or law school 20 years ago. It's not the decades-old complaint about liberal professors or what have you. I don't think the ideological mix has shifted all that much, if at all, either among faculty or students. What's changed is the illiberal quotient or mob has been placated by administrators, as we've seen an explosion of bureaucracy, especially these DEI offices, the
diversity,
which ironically,
equity, inclusion,
which ironically prevent intellectual diversity, stop equal opportunity, and exclude those who deviate from a rigid orthodoxy. And the administrators, the deans, the presidents, the provosts, department chairs, it's not like they've become woke radicals all of a sudden. No. They are bureaucrats trying to keep their heads down and giving oil to the squeaky wheels. And they've turned out to be spineless cowards.
Right.
I don't think Dean Traynor at Georgetown is some sort of revolutionary social justice warrior. No, but he is a spineless coward. And that's the problem, because whether we're talking about due process, whether we're talking about enforcing what in many places, including Georgetown, is a very well-written policy on free speech and expression, which says that someone taking offense is not evidence of any sort of violation or something like that. But they put paid to that kind of liberal sentiment in favor of the illiberal sentiment that speech is violence, etc.
Yeah, no, and to be very clear, FIRE just announced their power rankings of free speech on university campuses, and I don't know if Georgetown came in dead last, but if it wasn't dead last,
Georgetown
it was
is
near
in the bottom 5.
Yeah, there you
Georgetown's
go.
the bottom 5. The very worst is Columbia. The very best is the University of Chicago, where I went to law school.
There you go. I will say my alma mater, William & Mary, ranked number 12 on there, so I was very pleased to see that. So let's turn our attention to the Supreme Court a bit. We'll talk about the book in a second. The book, of course, Supreme Disorder: Judicial Nominations and the Politics of America's Highest Court. I want to talk about the recent situation.
Andrew, one more beat on the campus thing, or on cancel culture more broadly.
100%.
The thing is, I was able to fight back, and I sort of, I don't think as I talk about it now, I wasn't canceled. I resisted cancellation.
Sure.
But that's because I have
point.
A platform, I have a name, I can get published in the Wall Street Journal. I have friends who came out of the woodwork, and allies who came out of the woodwork to support me both publicly and in back channels to the dean and things like that. Most people don't have that. I'm not talking about celebrities who cares? They have FU money and it's a different situation. But so many people, if they donate to politically incorrect causes, say, get doxxed or fired or boycotted, or in Canada, frozen out of their bank accounts. This is a real problem.
And it's interesting. Actually, I'm going to shift in another place, because Congress is talking once again about the Disclose Act, which is this idea of making sure that donors to causes, that could heretofore be left anonymous, or you can give privately to an organization that you might support. They want to make those donations more public. Lots of discussion on dark money, even though the left is taking huge amounts of dark money right now. Don't want to make this necessarily left versus right thing. But you and I both know that the only reason why certain elements want greater disclosure of donors to issue-oriented causes, not electoral politics, is because they want to go after and harass those situations. The famous instance of Senator Dick Durbin turning around and going through, I think it was the donors to ALEC, the American Legislative Exchange Council. But that's the only reason
Cato got
why.
a letter that I drafted our response to that letter from Durbin. I just filed a brief 2 days ago, or joined a brief with 52 other organizations pushing back on DOJ subpoenas in Alabama. It regarded some sort of transgender policy thing, but the underlying politics didn't matter. The principle was DOJ was going after these third-party organizations that were advocating in various ways, and now they're getting these subpoenas. You're absolutely right. We have a history in this country of the freedom not just of association, but of private association, going back to the famous case of NAACP versus
exactly
Alabama.
Where I was going to go. That's why ironic that they would be doing this in Alabama, given that the very Supreme Court case took place. Talk to our viewers and listeners about NAACP versus Alabama, because it is such a seminal case, so important. Talk about it.
This was a case in the 50s where the state of Alabama wanted to know, purely for administrative purposes, to
Yes.
prevent charitable fraud, see.
Yes.
They wanted to know all of the donors to the NAACP in the 50s in Alabama. So think about that.
Yes.
And the Supreme Court said there is no good reason for you to do this. This is purely to facilitate harassment and worse.
Yeah.
And said, no, there's a tradition of private association. You don't have a good reason. Just a couple of years ago, the Supreme Court beat back a California statute that asked all charities soliciting funds in California, charities, not political action groups or lobbyists or policy groups, but all charities, for a list of their donors. And the Supreme Court said, this is you don't have a reason to do this. If you want to investigate fraud and you have good reason to suspect fraud, issue subpoenas after the fact and go about your investigation. But just at the outset, just a list of all donors, that's only nothing good can come of that.
Talk about the opportunity for abuse of that fraud investigative power, because our friends at the Competitive Enterprise Institute and other free market limited government nonprofits found themselves on the burning end, the sharp end of subpoenas from attorneys general over their climate change advocacy. I mean, that's the thing, right? We're now seeing an administration where they're going to label their political opponents as extremists and terrorists. I see that as an avenue for harassment. But also, when you label, something a subtle question of science, it opens your opponents up to being investigated for fraud. Talk about that.
Well, sure. I mean, there are governments engage in pretextual actions all the time, and we have seen an upswing of going after political opponents in this way. It's Nixonian, frankly.
Yeah.
That's the parallel. It's not Stalin. People always reach to the reductio ad Hitlerum or ad Stalinim or something, but it's not that. It's nobody's going to camps, but it is Nixonian.
Not yet, anyway.
Using the IRS and other investigatory agencies to go after your political opponents. And courts need to do a better job of policing that, as they have generally in this area, and CEI has been able to beat back, and other organizations and across different issue areas. Eventually they get relief, but sometimes the investigation is the punishment itself.
It's so funny you talk about that, because when we've talked about which administrations to compare this administration to, I invariably go back to Nixon, not just because of the abuse of power in vis-a-vis political enemies, but also because of the various big government economic issues. Not that I want to focus on that. I do want to turn to not just the book, But I want to turn to the shadow docket issue with the Supreme Court and the Yeshiva University case, because that was really interesting. What recently just happened there, the Supreme Court saying, you know something, there are limits to what we're going to take on this shadow docket. Talk about what the shadow docket is, and talk about the Yeshiva University case.
Well, what's been called the shadow docket is really the emergency docket.
Yes.
In fact, the person who coined the term shadow docket, Will Bode, a professor at the University of Chicago Law School, has said that it was a cutesy thing, but it's really emergency because the court is not doing things in the shadow without explanation or in secret, classified, or nothing like that.
It's not like the FISA court.
Right, exactly right. That's a good comparison. Which hides certain things because it deals with sensitive security issues and so forth, intelligence issues. But here, the Supreme Court has always had, the normal cases that it takes up for oral argument, with decisions coming by the end of June, as we're used to. But then there's emergency appeals, stays, motions to stay executions that are last minute, or some lower court did something. And if the Supreme Court doesn't put in a stay immediately, there's irreparable harm. Even if they ultimately prevail, the damage has been done. We've seen the confluence in the last decade or so of various factors that have led to an increase of action, and especially high-profile cases, on this emergency docket for various reasons. One is that lower courts have gotten more aggressive with nationwide injunctions. That is, a district court makes a ruling that affects the entire country, and so the Justice Department, the Solicitor General, has to go to the Supreme Court to put a stop to this. Another is COVID, with pandemic emergencies and very unusual procedural postures for various type of cases that have gotten there. And in general, the Solicitor General, the Attorney General of both parties, being more willing to go straight to the Supreme Court rather than waiting for the litigation to play itself out. And Justice Alito last year gave a speech talking about this. What are we supposed to do? We get these motions, we get these actions. We as judges have to have a duty to do this. Now, they've started setting some more of these emergency docket cases on the argument calendar, trying to do it expedited, but still trying to get an argument in at least, and more briefing. But that, of course, delays things. So, there's the trade-off. If it's truly an emergency, it's hard to act in that way. So, I think it's not that much of an issue. It would be nicer if the court took more regular cases and decided more things. But with certain things, it's not the court that's driving these sorts of trends. So
we're now, I think it's like 160 days since the Supreme Court leaker leaked the draft of the Dobbs decision. I'm going to say this, you can correct me if I'm wrong. I don't think there's ever been a point in American history where the court has been more politicized in the public eye. We continue to have protests going on at justices' homes. We have had one justice who was directly threatened with all kinds of violence and criminality against them. Talk about the book and the new edition now available in paperback, though if I get my next edition, I'll get it in hardcover because I love having my books in hardcover. But talk about where things are. In fact, talk about where things are now in terms of the politicization of the High Court versus when you wrote the first edition of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court.
Sure. I've been writing about the leak of the Dobbs draft. You can find that stuff on Manhattan Institute's website. It's unprecedented, not in the sense that we've never had leaks. We have. Roe v. Wade itself, the result was leaked to Time magazine a couple of days before the decision, so Time could design its cover the right way. But to have an unfinished draft, not the full opinion, in full, leaked months before it's ready, that sort of thing, and let alone in a high-profile case, probably the most significant case of the last 50 years, that is really has put a chill on the court's operations. And justices across the ideological spectrum have said as much, that there's a real tension, it was hard to work, there's mistrust, not perhaps as much between the justices, but the justices can't trust the other justices' clerks. I don't know if they've put safeguards in chambers now where the clerks I don't know, aren't allowed to print out drafts,
Sure.
or limiting the computer access to the internet. I have no idea what safeguards they put in place, but it certainly harms the operation of the court. Now, just last week, several justices said that they're expecting a report from the investigation by the marshal that the Chief Justice asked to conduct this is forthcoming. We in 2 weeks, less than 2 weeks now, is the start of the new term of the court. I would expect there to be a report to come out around the same time. Now, the report could say we didn't find out who it was.
Wow.
There's certainly a potential way of doing this leak. Old school, using burner phones and dead drops in public parks and things like this of hard copies, not like emailing reporters from your Supreme Court email or anything like that. There is a way of doing it to make it essentially undiscoverable. But we'll see what happens with this, because it really is a serious violation of the court's operations. Now, it might not have so much to do with the court's legitimacy. These are related, but I don't think the same issue. Most people don't think the court is less legitimate because there was a leak. This issue of legitimacy is one mostly brought by elites when they're talking about, well, does this decision impair public confidence? Most people in the public, they look at the court's decisions and say, I like that, I don't like that, and that's about as much as one thinks about these things. And there, the public confidence in the court is low now, but not historically low. The gap between Republicans and Democrats is certainly high, but it was high after the decision in Obergefell, the same-sex marriage case 7 years ago. So, these things, I think that the debate over legitimacy is overblown. Fundamentally, and this is to tie it back to what I found in my book, which was, I wrote because I wanted to look at the role that politics has played in our confirmation battles. And surprise, surprise, it's been a political process from the very beginning. George Washington had a nominee rejected for political reasons. But what we have now, what's different now, is that you have divergent theories of interpretation that map onto partisan preference at a time when the parties are more ideologically sorted and polarized than they've been since at least the Civil War, if not ever. And so there's no way to reconcile, there's no way to compromise. When there's a vacancy in one of these precious seats, everything goes to DEFCON 1, and it can't help but be politically fraught.
And it doesn't help to serve the Republic in the long term if we keep going down that road. Let's because I want to talk a little bit about you personally and what you've been up to. But let's do a quick preview, because you're right, we're 2 weeks out from the start of the 2020, fall 2022 term. What's on tap? What are the big cases we ought to be looking for?
Yeah, the Supreme Court is not resting on its laurels after this big controversial case. And let me be clear, last term really was the promised, expected, feared conservative majority coalescing. After a lot of misfires and false starts and disappointments going back to Nixon's campaign to turn over to reverse the Warren Court, or Dwight Eisenhower saying his only two mistakes were his two Supreme Court nominees, Warren and Brennan. Conservatives finally, the dog that caught the cop car in a sense last year. And not just in the headline grabbing cases on abortion and guns and religion. Statistically speaking, there were a lot more so-called ideological
West Virginia versus
salient
EPA
decisions, which I consider to be the most significant case of the term in terms of jurisprudence. So next term, we could be another such blockbuster. For example, affirmative action, the challenge to Harvard and UNC using race in admissions. This court is not reversing the civil rights gains of the 60s of the Warren Court. What it's doing is going back against the excesses, the gaudy legal wallpaper of the 70s, if you will, of
I like that.
the Burger Court. And so the Bakke case, which put in our modern affirmative action regime with diversity as the grand the sole value in many of these places, that was based on one justice's vote in a 1979 case. And I think the court, more likely than not, if they reversed Roe, are going to revisit that. But wait, there's more. You talked about West Virginia versus EPA and administrative law. There's a case this term called Sackett versus EPA about federal jurisdiction over puddles on
Oh,
your
yes.
property when you try to develop it in various ways. Navigable
yes.
waters of the United States. Very important issue for.
You know, when I teach on regulation, Ilya, I invariably go back to the navigable waters of the United States issue as the illustrative of the separation of powers between Congress and the administrative agencies, and the powers of the administrative agencies to interpret the law. We don't have to get into it today. We'll probably get into it on another show. I've spent a lot of time talking about this, but it's to me one of the great stark examples of the power of the agencies to interpret words so that they no longer navigable no longer means navigable. But I'm sorry, you go ahead. I interrupted you.
No, sure. You remember Masterpiece Cake Shop, the baker who didn't want to make
sure.
a cake for a same-sex wedding? Well, this time there's a case involving a graphic designer who didn't want to make a website called 303 Creative versus Elenis, also out of Colorado, also tangling with the Civil Rights Commission there. Here, there's no debate over whether, baking, or there was another case involving a florist, whether that's First Amendment protected expressive activity. Here, it's graphic design, website design, no question about that. So probably the court will finally rule four square against compelled speech in this case. Another regulatory case, national pork producers. California tries to regulate the national market in so many industries. Or in effect it does, because it's such a large state, and if you're an auto manufacturer, you're not going to create one set of cars for California, another set for the rest of the country. And so what emission standards it set become the national standard. This is a case about raising livestock of various kinds. And the pork producers specifically, this is an industry that only 0.2% of pork is raised in California in this country. And this is a market where you can't tell exactly where it originates, the way that it's raised here, butchered another place, packaged another place, etc. And yet California has put in very strident standards in the interest of animal safety about how pigs are to be raised, which would put out of business a lot of pork producers or otherwise increase costs. So thereby, California is having an impact on purpose on interstate commerce, which then resonates with what lawyers call the negative or inverse or dormant commerce clause. That is, Congress has the power to regulate interstate commerce. What happens when states start regulating it? Very important issue, and one that cuts across ideological grounds. So, for example, Justice Gorsuch and Justice Thomas are among the most skeptical about applying the Dormant Commerce Clause unless a state, puts on tariffs against imports from other states or something like that. So hard to predict how that goes, but a very important agricultural market and has ramifications for any state's regulations that have extraterritorial effect.
I want to shift gears for a second, because I was going to ask you about your school board run, whether or not you're going to run again. But I want to step even.
I've had a busy year.
Yeah,
Andrew.
I know you have. But I want to take a step back, because you recently posted. You talked about your college years. You recently posted at Shapiro's Gavel, your Substack, your college thesis at Princeton, Siberian law, Patagonian politics, following the death of Mikhail Gorbachev. Now, I talk about my fascination with the Constitution and federalism and regulation administrative law. I was fortunate to work for a blind environmental lawyer who happened to be the former Assistant Attorney General for the Environment and Natural Resources Division, a gentleman named Roger Marzullo, and developed my love of property rights and federalism. We worked on some fascinating cases. Where did you develop your love of these issues? Because you're passionate about them. Listen, I'm going to be unabashedly jealous of the fact it's times like these that I regret not having a JD. You have one. Like, I've got tears in my eyes just even thinking about it. But when did you become fascinated by these constitutional issues and these sort of core issues relating to who we are as Americans?
Well, I hope you spent those 3 years that you otherwise would have been in law school being productive. I'm sure you did, because it is a high opportunity cost on top of the cost of tuition and all that. And in fact, I advise.
Hold on, time out for a second. it's one of those things where under the old rules, if I'd stayed with Roger for another 2 years, I could have sat for the bar by reading into it, because I would have essentially fulfilled those situations. I just couldn't do it for another 2 years. I was totally burned out. But those 3 years I spent working for Roger. That's really what it was all about. I'm sorry, Ilya, go ahead.
I know him as well. Brilliant.
Yeah.
Part of this I covered in a post called "Living the American Dream," kind of autobiographical. I was born in the Soviet Union in Moscow.
That's right.
And my parents got me out, and we immigrated to Canada. I like to joke we took a wrong turn at the St. Lawrence Seaway, and the damn communism keeps following me around. But all my parents taught me was that communism was bad. And I sort of took it from there. And I was fascinated by history books early on. I was fascinated by the development of the American Constitution. I remember reading the Constitution fairly early on and thought, well, this is clear, this is short, this makes sense. In high school I read John Locke and the Federalist Papers and things like that, as well as, Ayn Rand and, lots of other things. I thought these ideas of liberty, these structural protections, you have this powerful government, but how do you force it to check itself, to paraphrase Madison's Federalist 51, separation of powers, federalism, all these great things. I was just fascinated by that, and I thought I wanted to go to law school, as I eventually did, because I like studying legal and political institutions, because, from my personal family history of the Soviet Union, obviously violating people's rights and freedoms in so many ways. And I liked all things international, whether sports or food or culture or politics. And so got to travel through, got my share of Princeton's endowment to travel to lots of different places and talk to people and learn about these things. And I spoke Russian, I learned Spanish. That's where the comparative constitutionalism in my thesis comes from. And it all built on itself. And I thought this is a fascinating thing, and I'd love to make my life's work. I joke I don't know what I want to do when I grow up, but I'm making my life's work studying these issues and trying to promote the institutions that maximally allow people to promote their life, liberty, and pursuit of happiness.
Remind me. So there are the two Ilyas, right? And both Soviet emigres, right?
Yeah, but very different, because he's from St. Petersburg and I'm from Moscow.
I get that, but I'm going down a road here, and then you have the two Volokh brothers, Eugene and Sasha. Have you guys ever done a 4-person panel on this? I mean, because it's really interesting. You don't obviously there are things you disagree on, but you all have such a respect for the law and such a respect for individual liberty, obviously born out of anti-communism from these experiences. Have you guys ever gotten together and had a panel discussion about this? Because if not, I want to set this up.
We haven't as such. That's a good idea. That's a really good idea. Ilya Somin, that's the other Ilya.
Yeah,
he's the smart one. I'm the funny one. That's how we divide up that labor. But he wrote a monograph for the I think the highest Hebrew International Assistance Society. I forget what it stands for, but they help me. They help most Soviet immigrants, at least from the first wave of Soviet Jewry, to resettle different places. Now they're helping refugees from other countries, not necessarily Jewish, but on their, I think, 100th anniversary or something like that, he wrote a monograph about that. I think you can get it's not too hard to find on his website at George Mason. See, I can plug other people's good work anyway, but yeah, you're right. The Volokh who are from Kiev, and Ilya Somin and I, that would be a great.
I'm going to have to, something.
Discussion.
I'm going to stick a pin in this, because I think CPAC this coming year we got to figure out how to do that, because I think it'd be great. Because I wanted to do this as a whole separate podcast. Haven't done it yet. I was conceiving of a podcast called Outside Interests, where we talk to people in politics and policy about stuff not having to do with politics and policy. You could talk about your run for the school board, but you said you have a great interest in food, great interest in sports. What gets you going outside of this work that you're doing? How do you on a weekend, how are you recreating?
I have 2 sons who are 6.5 and 4.5.
Wow.
So we're starting to get in sports, but even aside from that, we're just chasing them around in various ways. I have my wife and I have twins on the way this fall, so we're about
Hey,
to...
Mazel tov. That's fantastic.
Thank you. We're about to press the reset button on the craziness with the little ones. So, I take my boys to lots of sports games. I've been a 15-year season ticket holder of the Washington Capitals, big hockey fan. I get to lots of other sports as well. One of my recent Substack posts was about Bull Durham and constitutional reform and the Supreme Court.
Nice.
Love that movie. I've been to the Durham Bulls in Durham, North Carolina. I love the way that kind of culture and politics and sports intersect. That certainly enthused me in Argentina, where I've spent a lot of time. The role of soccer in politics is fascinating. One of their former presidents catapulted himself to that position from being the president of one of the soccer clubs, for example. I watch a lot of Netflix, as I think a lot of people have gotten in the habit of doing through the pandemic. I came late to Better Call Saul, but I just watched the entire run of Better Call Saul. I think that or The Americans might be my favorite series of all time. And I just try to hang out with my wife and stay sane. We're fortunate to have a pool. And so especially obviously in the summer, and we have a heater, so this progresses for another month. We just like to lounge by the pool and sip some wine and make sure our kids don't kill each other.
Plug the book, plug the Substack, plug the work that you're doing in the Manhattan Institute, Ilya.
Sure. The book is Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. And if you go to supremedisorder.com, not only can you find lots of different places to buy it, you don't have to go to Amazon, but you're welcome to. But for free, you can download a statistical historical appendix, a PDF, going through all the confirmation battles and more recent lower court battles, so you can be really popular at your next cocktail party. And as I said, available in lots of formats: Kindle, Audible, the new paperback, etc. The Substack is Shapiro's Gavel. You can just Google Shapiro's Gavel. You can sign up for free posts. Some are subscribers only. All the rest of it. If you become a founding member, then you can get a free signed copy of my book, for that matter. And then if you go to the Manhattan Institute website, and you can find me there. I'm very active in lots of things there. In fact, next Thursday, if you're in New York, we're having a Supreme Court preview moderated by Judge Steve Menashe of the Second Circuit, Georgetown professor Nick Rosenkrantz, my colleague Jim Copeland. So we're doing that. And I'm active on Twitter as well. So Google me, you'll find lots of good things.
Well, thank you so very much for joining us today, my friend. I really always love talking with you about these issues.
Good to be with you.
We've come to the conclusion of another Federal News Hour, Federal News Wire lunch hour. I'm your host, Andrew Langer. Enjoy the rest of your lunch. See you next week.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.